This episode was produced by Bach Pro Se. Run your own legal research at prose.trybach.com.
Imagine hearing this heavy, sudden knock on your front door, right? You look out the window and you see armed ICE agents standing there.
Yeah, that is a terrifying moment for anybody.
It really is. And one of them slides a piece of paper under your door, a warrant. Now, I think the instinct for almost anyone in that situation is to, immediately turn the deadbolt and just open the door.
Yeah, because you see a badge and you think you have to comply.
Exactly. But depending on exactly who signed that specific piece of paper, opening that door might actually be the single biggest legal mistake you could possibly make.
It really could.
Yeah.
Because, turning that knob changes everything. The very moment you open the door, you've provided what the law considers consent.
Wow.
Yeah. You literally take away your own legal protections before the interaction even begins.
And we know, some of you tuning in to this deep dive are dealing with a very specific, very heavy kind of anxiety right now. You might be afraid to drive to the grocery store. Or you might have a family member who just vanished into a detention center yesterday. Or maybe you're staring at a letter saying your temporary protected status just evaporated.
It is a lot to carry.
We see you. And the mission today is to give you a calm, purely factual, and empowering guide to your rights. We are specifically focusing on the landscape in Florida.
Because, look, the news is just saturated with political noise.
Right.
Fear-mongering, incredibly complex legal jargon.
Oh, yeah, it's overwhelming.
But the law itself doesn't operate on noise.
Yeah.
It operates on specific mechanisms. It operates on statutes, constitutional precedents, and really hard deadlines.
Right.
Understanding those mechanisms, that is how you survive.
So to understand those mechanisms, I've been going through this totally fascinating stack of legal materials from Bach Pro Se. And just a quick note, that is spelled Prose, but it's pronounced Bach Pro Se.
Right.
We are looking specifically at their Florida legal help materials, the Episode 9 instructions.
There is a ton of vital information in there.
There really is. We're going to pull apart the constitutional rights you have during an enforcement encounter, the really hard reality of the 2026 temporary protected status expirations, the cascading effects of Florida Senate Bill 1718, and, the exact step-by-step playbook for finding a detained loved one.
It is a massive agenda.
Okay, let's unpack this. If we're looking at the law as a mechanism for protection, I think we have to start with that knock at the front door. The Bach Pro Se materials heavily emphasize the Fourth Amendment.
They do, and for good reason. The Fourth Amendment protects everyone on U.S. soil from unreasonable searches and seizures.
Notice the phrasing there. Right. Everyone.
Exactly. It applies to everyone on U.S. soil. It doesn't, ask for a passport or a visa first. If law enforcement is at your home, that amendment is your barrier.
Which is huge.
Right. They generally cannot force their way inside without either your explicit consent, which, again, you give by opening the door, or a highly specific type of warrant.
Now, this is where I really want to drill down, because looking at these briefs, it becomes pretty obvious that not all warrants are created equal.
Oh, definitely not.
If an agent slides a paper under your door, you need to look directly at the signature line. What is the actual difference between a judicial warrant and an administrative warrant?
That difference is the entire ballgame. Really. A judicial warrant is signed by a neutral magistrate or a judge.
Okay.
And neutral is the key word there. It
Yeah.
means the person signing it does not work for ICE. They don't have arrest quotas.
Right.
They've reviewed the evidence and objectively decided there is probable cause, meaning enough factual evidence to suspect a crime to allow agents into your home. If they have a judicial warrant, they can enter.
But the Bach Per Se documents warn really heavily about administrative warrants. Specifically, Form I-200, which is an arrest warrant, and Form I-205, which is a warrant of removal.
Yeah, because those are signed by an ICE officer, not a judge.
Wait, so an administrative warrant is basically ICE writing a permission slip for themselves. Doesn't that defeat the entire point of the Fourth Amendment needing a neutral judge?
Well, historically, an administrative warrant absolutely did not give agents the authority to break down a door or force entry into a private residence without consent. They could wait outside, sure, but they couldn't just come in.
I was reading about a major shift that happened recently, though.
Oh, the 2025 memo.
Yes. In May 2025, the Department of Homeland Security issued an internal memo completely reversing that policy. They suddenly claimed that Form I-205 administrative warrants do give them the authority to enter a home to arrest someone with a final removal order.
Yeah, that caused an absolute uproar.
How is that even possible? How can an agency just write a memo that bypasses the Fourth Amendment?
Well, they can't,
Huh.
which is exactly why legal scholars immediately took them to court. Federal courts in California and Minnesota have already ruled against the DHS on this.
Oh,
Yeah, they declared that the May 2025 memo violates the Fourth Amendment precisely because it lacks that independent check by a neutral judge.
so for you listening, the practical takeaway here is this. If they slide a Form I-200 or Form I-205 under the door, and there is no signature from an actual judge, you do not have to open the door.
That is exactly right.
You can just state clearly through the closed door, I do not consent to your entry.
Yes.
But, let's move away from the house for a second, because the rules seem to change dramatically the second you step onto the sidewalk or into a grocery store parking lot.
They do. It is a very different environment.
I'm looking at the federal code here, 8 U.S.C. section 1357A2. It seems to give ICE a much, much wider net in public.
It does. Under that statute, ICE has the authority to arrest someone without a warrant in a public place if they have, well, quote, reason to believe the person is in the United States unlawfully and is likely to escape before a warrant can be obtained.
Reason to believe?
Yeah. It functions very similarly to probable cause in this specific context.
Now, you say we still have Fifth Amendment rights here, the right to remain silent, and that we can just ask, am I free to leave?
Yes, you absolutely can.
But I have to push back on how practical that actually is. I mean, let's be real. If 3 armed federal agents suddenly surround you at a gas station asking, am I free to leave, feels almost impossible. People panic. What actually happens in these street encounters?
It is terrifying.
Mm-hmm.
And law enforcement often relies on that terror. They rely on the psychology of authority.
Right.
When agents approach you, they often try to frame it as a consensual encounter. They just want to, ask a few questions.
So casual.
Exactly. But if you start answering where you were born, how you entered the country, you are actively giving them the evidence they need to justify the arrest.
That is wild.
That is why invoking the Fifth Amendment is so critical. You are not legally required to discuss your citizenship status.
Okay.
Asking, am I free to leave, literally forces the agents to legally classify the interaction. If they say yes, you walk away slowly and never run.
Do not run.
Running creates reasonable suspicion and immediate physical danger.
And if they say no, you are being detained.
Right.
At that point, you invoke your right to remain silent and state you want an attorney. But the Bach Pro Se materials highlight a really harsh mechanical reality of the immigration system here. If you get arrested for robbing a bank, you get a free public defender because it's a criminal case.
Yes.
But immigration encounters are classified as civil proceedings.
Which means the government has zero obligation to provide you with a lawyer.
None at all.
Zero. You have the right to an attorney, but you have to find one and pay for one entirely on your own. Yeah. Or you have to scramble to find a pro bono free legal aid organization.
That is a massive financial and logistical burden on a family.
It is crushing.
And what's wild is that these terrifying encounters, the knock at the door, the arrest in the parking lot, they often don't just happen randomly.
No, they usually don't.
They happen because an invisible administrative deadline on a calendar suddenly passed. Which brings us to the second major topic in our stack today, the collapse of temporary protected status, or TPS.
Right, so TPS is governed by 8 U.S.C. Section 1254A. The federal government grants it to nationals of specific countries who basically cannot return home safely for one of 3 statutory reasons.
Okay, what are they?
An ongoing armed conflict, an environmental disaster or epidemic, or other extraordinary and temporary conditions.
Right.
It provides a work permit and shields you from deportation.
Right.
But the defining feature of TPS is right there in the name. It is temporary.
Yeah. The Secretary of Homeland Security reviews these country conditions periodically, and right now we are witnessing a massive rolling wave of 2026 terminations.
It is unprecedented.
I want to read these dates directly from the source material because this is urgent for anyone listening. If you are from Yemen, your TPS ended on July 20.
Right.
Haiti and Syria terminated on July 27. Burma and South Sudan ended on August 7.
And we just passed another huge one.
Yes. Crucially, Somalia's TPS terminated yesterday, August 14th, 2026.
We also really need to flag the extremely complex situation for Venezuela.
Oh, yeah, the October deadline.
Venezuelan TPS holders have employment authorization documents, EADs, that expire on October 2. They have to act immediately.
What exactly is the mechanism of losing TPS, though? Like, what actually happens the day after that termination date hits?
It's an instant reversion. The protective shield just simply vanishes. Your work authorization expires, meaning your employer legally has to let you go.
Wow.
And legally, you revert to whatever immigration status you held before TPS was granted. For the vast majority of people, that means returning to being undocumented and immediately vulnerable to the enforcement encounters we just discussed.
And to make it even worse, Congress recently passed the One Big Beautiful Bill Act,
Right.
which officially eliminated the automatic extensions of those EADs that people used to really rely on while waiting for renewals or adjustment.
It pulled the rug out from under thousands of people.
I can imagine people wanting to sue the government over this. I mean, if conditions in a country are still terrible, how can the secretary just unilaterally end the protection?
Because the statute explicitly prevents them from suing. 8 U.S.C. Section 1254A contains a really strict no judicial review provision.
So courts can't even touch it.
Exactly. Federal courts are legally barred from reviewing or overturning the Secretary's decisions on which countries get TPS and which ones are terminated.
That feels incredibly bleak. But digging into the Bach Pro Say instructions, I found a mechanism that is critical. Here's where it gets really interesting. It's a literal lifeline, but it operates on a very strict timeline. It's the asylum clock stopping rule.
Ah, yes.
This is under 8 CFR 208.4A4. Let's use a metaphor to explain this because the math is honestly pretty tricky. Think of your eligibility to file for asylum as a stopwatch that only has 1 year on it. Normally, you have to file within your first year of arriving in the U.S.
Right. And getting granted TPS qualifies as an extraordinary circumstance that basically hits the pause button on that stopwatch.
But here's the trap. The moment your TPS is terminated, the stopwatch doesn't reset to 0.
No, it does not.
It just unpauses. Let's say you arrived in the U.S. and lived here for 11 months before you were finally granted TPS. The stopwatch paused at 11 months.
Yep.
3 years go by, and yesterday, your TPS for Somalia was terminated.
The stopwatch immediately resumes. You don't have a year to figure out your next move.
Yeah.
You have exactly 1 month left on that clock to file your asylum claim.
Only 1 month.
If you miss that remaining window, you're generally barred from asylum forever. This is why understanding the exact timeline of your specific case isn't just paperwork, it's survival.
Okay, so we have these federal protections evaporating and federal stopwatches resuming. But if you live in Florida, the state level is essentially throwing gasoline on this fire. State laws are creating a cascading effect that forces interactions with federal immigration. Let's look at Florida Senate Bill 1718.
Yeah, SB 1718 is sweeping.
It essentially attempts to weave immigration enforcement into daily civilian life.
A prime example is Section 908.104. That section mandates aggressive cooperation between state law enforcement and federal immigration agencies.
Okay.
But the real cascading effects happen in employment and mobility. Let's start with driving. Under Section 322.033.
This one is fascinating and terrifying. Under this section, Florida invalidated certain out-of-state driver's licenses.
Yes, they did.
If you hold a license from a state like New York or California that issues a specific class of license to undocumented immigrants, Florida literally no longer recognizes it as valid.
Let's trace how that cascade works.
Yeah.
Right? You lose your TPS because of a federal decision. Because you lost status, maybe you rely on an out-of-state license.
Right.
You drive to the grocery store in Florida. A broken taillight leads to a routine traffic stop.
Right.
Because of Section 322.033, the officer cites you for driving without a valid license. You are arrested.
Oh, wow.
And then because of Section 908.104, the local jail cooperates with ICE. Within 24 hours, a broken taillight has turned into a federal detention and removal proceeding.
It's a complete domino effect. And the state is also putting massive pressure on employers. Section 448.095 requires any private employer in Florida with 25 or more employees to use the federal E-Verify system.
Right, to check the work authorization of every new hire.
Exactly.
It deputizes corporate human resources departments. They are forced to act as the first line of immigration enforcement.
That's a huge burden on businesses.
If an employer is caught knowingly hiring an unauthorized worker, the state hits them with severe penalties. We're talking probation, revoking business licenses, even forcing them to pay back state economic incentives. It forces businesses to comply out of pure self-preservation.
The Bach Pro Se materials also dive into Section 395.3027. That's the hospital provision, which caused just massive panic when the bill passed.
The confusion around that was terrible.
It requires Florida hospitals that accept Medicaid to ask patients on their intake forms if they are U.S. citizens, Lawfully present or not lawfully present.
Yeah.
I want to stop here because this is where rumors cause real physical harm. People are avoiding emergency rooms because they think hospitals are going to deport them.
We really need to look at how state law crashes into federal medical law here.
Right.
The state of Florida mandates that the hospital asks the question and submits quarterly anonymous data reports. But federal law, specifically EMTALA, the Emergency Medical Treatment and Active Labor Act, mandates that hospitals cannot deny emergency stabilizing care to anyone, ever.
Exactly. I was reading the exact requirements for the intake form. The hospital form physically must state that your answer will not affect your care.
Yeah.
It also states your personal identifying information is not being reported to immigration authorities. So this hospital question is basically like a voluntary customer survey.
That is an excellent way to think about it. Practically speaking, what happens if a patient just refuses to check a box?
Yeah, what happens?
Nothing. Nothing happens to the patient. You can leave it blank. You can literally write decline to answer. The hospital is legally obligated under federal law to treat your emergency.
Thank goodness.
You do not have to risk your life or your child's life because of a state data collection question.
That is such a critical piece of knowledge to hold on to. Now, SB 1718 also tried to flex state power by creating a new third-degree felony. This is under Section 787.07 for human smuggling. It made it a severe crime to knowingly transport someone into Florida who entered the U.S. unlawfully.
But you have to track the living law, not just what was signed on camera during a press conference. Federal court stepped in. A federal judge formally enjoined, or blocked, the enforcement of that specific human smuggling provision earlier in 2024.
To clarify, enjoin basically means a federal judge hit the pause button on the state law because it likely violates the U.S. Constitution.
Yes, perfectly said. The federal government has the exclusive authority to regulate immigration. States cannot just create their own parallel immigration criminal codes.
Makes sense.
But while that provision was blocked, others stand. The law successfully restricted local governments from using taxpayer money to fund community ID programs.
Though it's important to note, private organizations in places like Broward and Miami-Dade counties actually stepped up and are still funding those ID programs privately.
Right.
They operate completely outside the state government's reach.
Which highlights a fundamental truth here. Florida can pass aggressive laws, but the U.S. Constitution does not evaporate at the state line.
The Supreme Court settled this decades ago. The Bach Pro Se briefs cite two really monumental cases. You have Yikwo v. Hopkins from 1886 and Plyler v. Doe from 1982. The 14th Amendment says no state shall deprive any person of life, liberty, or property without due process of law.
Any person.
Notice the vocabulary. Yeah, it says person. It does not say citizen. If you are physically breathing within the borders of Florida, those constitutional protections apply to you.
They absolutely apply in theory, but having constitutional rights and successfully defending them while you are, sitting in the back of an ICE transport van are two very different realities.
That's the hard truth.
The systems fail. Mistakes are made constantly. People get caught in sweeps. We really have to walk through the worst-case scenario. If the front door opens or the traffic stop escalates and you or a family member are taken by ICE, what is the immediate step-by-step playbook?
Yeah. If someone doesn't come home and you suspect ICE detention, the immediate instinct is to panic. But panic wastes time. Your first tool is the ICE Online Detainee Locator System, but I noticed a huge caveat in the source material. There is often a 24 to 48-hour delay before a newly detained person's name actually populates in that online database.
And that 48-hour window is agonizing for families, just agonizing. If the online system isn't working, you move to the phone. You call the ICE Detention Reporting and Information Line directly at 1-888-835-1024.
You also need to know geographically where people are taken. If you are in South Florida, there are 3 primary black holes where people usually end up.
Right.
The Chrome North Service Processing Center, which is physically located at 18201 Southwest 12th Street in Miami. There is the Broward Transitional Center further up in Pompano Beach. And then there is the Baker County Detention Facility.
Once you locate them, the legal mechanism shifts to the immigration courts. You need to know their case status, which you can find by calling the EOIR hotline, that's the Executive Office for Immigration Review, at 800-898-7180.
Okay.
The immediate goal is getting them out of physical custody so they can fight their case from home. That requires requesting a bond hearing.
But the judge doesn't have to grant bond, right? Like, it's not guaranteed.
No, and in some cases, they legally cannot. If the individual has certain prior criminal convictions, the law triggers mandatory detention.
Oh.
That means the judge's hands are totally tied. No bond is possible, and the person must remain locked up for the duration of their immigration proceedings. This raises incredibly severe secondary issues, particularly regarding parental rights.
The materials mention this, and it's honestly heartbreaking. If a parent is locked in mandatory detention for months or years, the state of Florida can actually initiate proceedings to terminate their parental rights simply because they are physically absent and unable to care for their children.
Time is your absolute enemy in detention. You cannot wait to see if things will just work out. And because, as we established earlier, there are no free public defenders in these civil immigration cases, finding representation instantly is paramount.
I'm going to read a very specific list of organizations in Florida that provide free or low-cost immigration legal services. If you're listening, write these down, put them in the Notes app on your phone. Do not wait until you are allowed one phone call from Chrome North to try and Google them.
Yes, be prepared.
You have Broward Legal Aid, Catholic Legal Services, Florida Justice for Our Neighbors, the Florida Immigrant Coalition, and the Americans for Immigrant Justice Detention Program. Having these names ready is how you fight back against a system designed to overwhelm you.
Because when you are on the inside, wearing a uniform, trying to gather documents and make phone calls to lawyers you've never even met, the logistical hurdles are exponentially harder. Preparation on the outside is really the only advantage you have.
We have covered a massive amount of dense, critical information today. So what does this all mean? We started with the physical reality of the Fourth Amendment at your front door. The vital difference between an administrative Form I-205 signed by an ICE officer and a judicial warrant signed by a neutral judge.
Right.
We unpacked your Fifth Amendment right to remain silent in public encounters and ask, am I free to leave?
We track the urgency of the 2026 TPS expirations, particularly the immediate fallout for Somalia and Venezuela, and how the asylum clock stopwatch resumes the second that protection drops.
And we mapped out the cascading traps of Florida's SB 1718, clarifying that you do not have to answer a hospital's immigration question under EMTALA. Finally, we gave you the playbook for locating a detained loved one and finding free legal help. Your constitutional rights do not evaporate because of your immigration status.
If we connect this to the bigger picture, as we close, I want to leave you with something to really think about. We discussed federal courts blocking the DHS from entering homes without judicial warrants. We discussed federal judges blocking Florida from enforcing its own human smuggling laws.
Yeah.
What we're really witnessing is a massive real-time collision between state power, federal agencies, and the judicial branch. As a listener trying to survive in the middle of this complex web, how do you protect your family when the very agencies tasked with writing and enforcing the law cannot even agree on what the Constitution actually allows?
It is a totally sobering question. When that heavy knock comes at your front door, the Supreme Court isn't standing in your living room to interpret the law for you. You are the only one standing there. Know the mechanisms, check your deadlines, and hold your rights close. Thanks for joining us on this deep dive.
This episode was produced by Bach Pro Se. Run your own legal research at prosay.tribach.com.